you're good to go.
Okay, so we're live.
Yep.
All right, welcome everybody. Thank you for tuning in. I'm Sarah Morris from Morris Law Center. Today we're just going to talk about what to expect if you do think that you need to file a lawsuit in Clark County. There are different jurisdictional limits depending on what your damages are. So the lowest amount is going to be small claims, and that has a jurisdictional limit of $7,500, meaning that anything up to $7,500 you can file in small claims court. The filing fee is a lot less. I think it's around $70 to file. So your costs are going to be less if you go to small claims, and it's much more relaxed when we talk about generally how a case moves through litigation. I'll reference small claims, but in the small claims context, it's very, very relaxed. There's no formal discovery. It's not a formal trial. The rules of evidence are relaxed. It's an easy process that you can do on your own if you need to. Then after small claims is justice court. And I'm sorry, you know what? The small claims limit changed. It's now $10,000. It used to be $7,500 and it changed. So now we're at $10,000 for small claims. Justice court is also $10,000 limit. And then you get to district court, which is over $10,000. So if you're at the district court level, then the filing fees are going to be more than small claims. They're a little over $200 to file a complaint, which is the first thing that you do in a lawsuit. So let's say you want to sue somebody and you think you have grounds to sue them. You're going to need to file a complaint with the court. So the first thing is filing the complaint. And once you file your complaint, there's certain things you're going to need to do, which includes serving it on the other side. So depending on how many defendants there are, you're going to need to serve the complaint on the defendants. And that's going to cost you more money. So when you're talking about fees, Brian Morse is sitting over here replaying what I'm saying. Thanks, Brian. Okay. There's going to be fees for service. You're going to want to go to a stop. You're going to want to go. You're going to have to use a process server. For small claims, it's again going to be less. It's around $26. You can have a constable serve it on the defendant. For district court, it's going to be probably a little bit more. Plus, if you don't know where the defendant lives or you don't know where to find the defendant, then it's going to be harder. They're going to have to do a background search on them, which will cost more money. So once you file it, you serve the complaint. Then once the complaint is served on the defendant, then they have 20 days to answer. So 20 days to answer the complaint. And sorry, my handwriting's horrible. Once they answer the complaint, then you're going to want to, if you're in small claims, we'll talk about that first because it's the easy one. They answer there's mandatory mediation in small claims court, which isn't a bad thing because a lot of times these cases will settle at mediation and then you never have to go to trial. You don't have to present your witnesses and your evidence. You can just go to a neutral third party and you talk it out, and usually you're in separate rooms and sometimes you can come to an agreement. So there's mandatory mediation for small claims. If that doesn't work, then you go to court. And that first court appearance after mediation is essentially your trial. So you want to make sure that you bring everything to that court appearance. Any documentary evidence you have, any witnesses that you want to testify or to help you out. So you got to be very, very prepared. A lot of people come in there not realizing that this is their chance. This is their chance to tell the story, and that's the only chance they get. So, and like I said, the rules of evidence are relaxed in small claims, so there's not going to be a lot of objecting or stuff like that. You don't have to worry about that. It's just basically an opportunity for you to tell your story. Now, if you're at the district court level, it is a lot more complicated. Once the defendant answers, then you as the plaintiff are going to want to set an early case conference, because until that has been set and taken place, you can't go through discovery. So you're going to want to set your early case conference. That's the next step after. So we've got complaint, answer, then you set your early case conference. And what that is basically is it's an opportunity for you and the other side to sit down, and you have to provide whatever documents that back up your claim, and they provide their defensive documents. So you're going to have to prepare a 16.1 production. I understand this might be a little complicated for those of you that have no idea what I'm talking about, but I'm just trying to give you an overview of what happens in a case if you're going to district court, because a lot of people don't realize that it is costly, expensive, and it takes a long time. So you get your early case conference set, you go to it, and then you've got to create a joint case conference report. And this is very important, and that is basically your discovery outline, like of how long you have for discovery. So during your early case conference, you're going to talk about how long you think it'll be for trial, how long the discovery period you want, if there's any problems with discovery or anything that you anticipate. So once you do that, after this is filed, this is when your discovery really begins. And to give you, again, we're just doing a broad overview. So generally, you're going to have written discovery. So you're going to want to send out written discovery, which is basically questions to the other side. You can ask for documents, you can ask questions. That's where you're going to do this, okay? And this takes a while. Then you're going to want to depose the other side, so there'll be depositions. And this is another place where there's costs involved. Because you got to have a court reporter depose the other side. The court reporter has fees. Maybe you're going to videotape it. That's an additional fee. So this can run up the costs, okay? And sometimes, if it's a very complicated case, you're going to want an expert. So just something else to consider. Do you want an expert? And experts are notoriously expensive. So, but you may need them depending on what kind of case you have. So you got to think about that, and there's going to be certain deadlines for you to disclose the experts, and that's going to be in your joint case conference. Well, the discovery commissioner is going to set the deadlines, but you're going to suggest deadlines in the joint case conference report. So once all of this is done, then you get to the point where you're getting ready for trial. And a lot of times trial doesn't occur for a couple of years. I mean, this isn't a quick process in district court. Like I said, small claims very quick. You file your EM2, you go to mediation, it does or doesn't work, and then you go to trial, and that's it. So it's a very quick process. It's easier for people to handle, especially if you have claims under 10. You're going to have to do it that way, but you want to do it that way because you're going to get a result quickly. So in this case, it's going to be a while. You're going to get to the trial phase, and before you get to trial, there's all kinds of motions you're probably going to want to file. There's pre-trial memos that you're going to want to file, and I won't get into that now because it's too complicated, and most cases don't go to trial, thankfully, because you settle before trial. So I just wanted to give a general overview of what you're looking at if you really, because a lot of people say, oh, I want to sue, I want to sue, I want to sue. Well, that's great. People don't understand that it costs a lot of money, a lot of time involved. If you've got an attorney, they're billing hourly, it's going to cost you a lot. So to give you a better understanding of the court process, you can refer to my lovely picture, which I don't even know if you can read. But do we have any questions?
We do not at the moment.
Okay, all right. And we've got the man behind the camera, Adam at Unser Communications. He's amazing. If you need a PR marketing company, you should contact him. Just a side note. but anyway, okay, so I hope this helps some people. If you guys have any questions, as always, you can always contact our office. We'd be happy to talk to you. And don't forget to subscribe to our blog. And I think that's it. Thank you so much for tuning in.